suppressed.
We gotta like keep the names until Wednesday.
I know.
Hi. Hello. Good evening, everyone. My name is Nicole Smith-Futrell. I am the faculty director of the W. Haywood Burns Chair Program here at the law school, also the Center for Diversity in the Legal Profession. Some of you might also know me from Defenders Clinic or Crim Pro. I've been a lot of different places, wear many hats. But I just wanted to say welcome. Thank you to all of you for being here this evening. We're delighted to have you for this event. And I want to welcome you to the W. Haywood Burns Chair Lecture Series discussion, The Revolution Will Not Be Litigated panel discussion. I want to start by acknowledging that it's an understatement that these are extremely trying times for all of us. We are surrounded by persistent human rights abuses, by war, by death, by despair. And in moments like these, I try to ground myself by staying connected to the work and the legacy of so many freedom fighters that came before us. And W. Haywood Burns was really one of those freedom fighters. For those of you who are not familiar with Haywood Burns, he was a people's lawyer, a professor, a civil rights activist who served as the second dean of CUNY Law School and the first Black dean of a New York law school. Before he was dean, he served on the front lines of many of the great civil rights struggles of our time. And while he was dean, he mentored and inspired a generation of students, many of them like you in the room, who were the first in their families and the first in their communities to go to law school, to go to college, to earn a law degree. And this program was established in 1997 after his untimely passing to honor his legacy. The Burns Chair Program brings a lawyer, an activist, or legal educator who has made important contributions to the discourse on racial, economic, and social justice to the law school as a visiting faculty member to engage in the intellectual life of the law school. The Burns Chair was sort of out of commission for a while, and we just reinvigorated it this year, actually, in 2023. And we have been so incredibly fortunate to have the support of the New York State Legislature, of friends and family, members of Haywood, of the CUNY Law Foundation. And with that support, we were able to do something really remarkable and tremendous, and that was to get Vince Warren to be our Burns Chair. And so for those of you who have not had the privilege yet of having an interaction with Vince, this is Vince, he's sitting in the middle right there. Hello, Vince. Is the executive director of the Center for Constitutional Rights. He's a renowned expert on racial injustice, discriminatory policing, and his whole life's work and his career really reflects so much of what Haywood Burns stands for, his legacy continues to stand for, and he really is the perfect person to reinvigorate this chair for us at CUNY Law. For those of you, he is teaching movement learning this semester. I don't know how many of you are in his class, but for those fortunate few, you know what I'm talking about when I say he is truly a dynamo and outstanding. He's had a number of awards. I'm not going to list them. Just go on the website, look it up. Trust me, he is distinguished in his awards, and we are all really, really pleased that he is visiting with us as our Haywood Burns Chair. So tonight, Vince will lead a timely panel discussion with some brilliant lawyers and activists who will inspire you with their experience and their commitment to bringing about change. So to introduce our panel, we have Majesty Houston, who's a 2L student here at CUNY Law, and a proud BALSA member who will introduce the panel. Thanks, Majesty.
Good evening. We are very fortunate this evening to be joined.
Oh, hey.
Yeah, I just want to put that up. Please,
To be joined by lawyers and activists who have worked on their front lines of human nature issues around the world. In The Revolution Will Not Be Litigated, they share stories of their collective struggles for social justice and how positive impact can happen even in the face of resistance. Their experiences are invaluable to law students who want to use the law as a tool to shift power and advance meaningful social change. Joining our Barnes Chair, Vince Warren, in a panel discussion this evening, we have several distinguished guests. Starting off with Alejandra Anjera, is a Mexican lawyer and an activist and a leader of the human rights movement for migrants, workers, and indigenous communities of her native country. She is founder and executive director of the Mexico City-based NGO Pro-DESC, the Economic, Social, and Cultural Rights Project. Among her most notable accomplishments at Pro-DESC, she achieved unprecedented results establishing accountability mechanisms for transnational corporations in Mexico. She was awarded the Martins Annals Award for Human Rights Defenders in 2014. Her essay in the book is entitled Building Space of Hope, Working for Indigenous Peoples' Rights in Mexico. Next we have Baher Azmi, who is the legal director of the Center of Constitutional Rights. He directs all litigation around issues relating to the promotion of civil and human rights. At CCR, he has personally litigated cases relating to discriminatory policing practices, stop and frisk, government surveillance, the rights of Guantanamo detainees, and accountability for victims of torture. Prior to his tenure at CCR was a professor at Seton Hall University School of Law, where he taught constitutional law and directed the Civil Rights and Constitutional Litigation Clinic. His essay in the book is entitled, Who Owns the Streets? Ending Discriminatory Policing in New York City, as well as 5 key ways a legal strategy can help a movement. Justin Hansford is a professor of law and executive director of Thurgood Marshall Civil Rights Center at Howard University School of Law. Professor Hansford is a lawyer, leading scholar, and activist in the areas of critical race theory, human rights, and law and social movements, and a member of the United Nations Permanent Forum on People of African Descent. In the wake of the killing of Michael Brown in Ferguson, Missouri, Hansford worked to empower the Ferguson community through community-based legal advocacy. His essay in the book is entitled Leadership and Learning Lessons in the Black Lives Matter Movement. Next, we have Katie Redford. She's a lawyer with an expertise in human rights, climate change, and corporate accountability. She's the founder and former executive director of Earth Rights International, and is currently the executive director of Equation Campaign, which is an organization that confronts the climate crisis by supporting movements on the ground to keep fossil fuels in the ground. Katie is a co-editor of the book and author of one of its essays entitled The Revelation Will Not Be Litigated, The Lawyer Perspective on Doe versus Unico. I now turn it over to Burns Chair Vince Warren.
Thank you so much, Majesty. Really, really appreciate that. And welcome to this program. I think you're really, really going to enjoy it. I'm really glad that Professor Smith-Futrell did not read the stupid awards that I got. Because really, honestly, one of the things that means the most to me is being here at Trinity Law School. I have the pleasure of teaching with an extraordinary teacher, Professor Margaret Stavropoulos. I'm having such a wonderful time learning and teaching in my movement learning class. Shout out to the students who could come tonight. Many couldn't because of scheduling conflicts. And it's been a wonderful experience because through the Burns Chair program, since I've been here, we've had a introductory discussion that I had with Janae Nelson of NAACP Legal Defense and Educational Fund about the shifting roles and generational changes in traditional civil rights organizations. Had a wonderful book talk of Becoming Abolitionists with Derica Purnell, who really just sort of lit it up, and wonderful to be in conversation with her. We also were able to bring people from the sexual minorities Uganda movement here to CUNY Law School, both as part of an educational piece for the students and the faculty, but more importantly, because of the anti-homosexuality bill in Uganda, human rights defenders, sometimes it's too dangerous to stay where they are, and that they need to connect with their comrades internationally to be able to sort of regroup and to think, to be safe, and so that we were able to bring our colleagues here to be able to address folks at the UN and other places. This panel discussion tonight, I'm just going to say two things about what you need to do. One is that you need to silence your cell phones, and the second thing you need to do is buckle up. Because this is a wonderful, wonderful group of extraordinary people. And I just want to give a broad framework of the type of lawyering that we're talking about. So we're talking about social movement lawyering, which differs from traditional lawyering in many, many, many important ways, some of the ways that you'll hear about tonight. It's also different from public interest lawyering. Public interest lawyers, we work on behalf of the public and in the public interest, but the methodologies that are used are not always, that tend to be client-centered or issue-centered, and they're not necessarily connected to the social movements and communities that are actually making social change. And so the type of lawyering that's represented in this wonderful group and in this book, which we have copies for all of you. If you want to get them signed, you should definitely read it. But the type of lawyering that we're talking about here is the lawyering that actually supports social change. Straight up social change, social transformation, social disruption, all of the pieces that are important in disrupting the status quo, which interestingly enough, they don't really teach you how to do in law school, unless you come to CUNY Law School. This is what we kind of teach you to do. I just want to say hi to Jennifer Dorn, who's here, who's a great friend of the law school, partner to W. Haywood Burns. She's sitting here in the front.
Thank you.
Yeah. And to the children that are here as well. But it's great, wonderful to see you all, and it's wonderful to be in this chair, which I understand is invigorated. So if I'm squirming, that's what that's about. So let's get started. Katie, you came up with the idea for this book. What sort of motivated you to pull together some stories, not just about the lawyering that happened, but also about the communities that we're partnering with the lawyers to be able to make change? See what you did right there?
Thanks. Hey everyone, it's so great to be here and so good to see so many people. I have to say, I used to organize these things when I was in law school, and this many people did not come to my events, even when I bribed them with food and drink. And I think that actually is one of the things that inspired me to pull together the stories and to help make this book happen, was because I just felt like this is what I wish I would have had in law school. I graduated from the University of Virginia School of Law many, many years ago. And like many and most traditional legal educations, you go to law school thinking, like I did, most people go to that they want to work for change and justice and the rule of law and truth. And I certainly wanted to go to use the law to fight for the underdog. And I had seen all the Hollywood movies. Hollywood loves that trope. And then I got to law school and I was like, well, wait a second, I'm reading stuff that's written by judges and academics and Supreme Court justices most of the time, if it makes it into a case book. Where's actually the lived experience? Where is the practical experience? How do you actually do this work on the ground in real life? And maybe you get that at a school like where I went, in a clinic, But in Charlottesville, Virginia, there wasn't a whole lot of experiential learning for the kind of work that I wanted to do, which was human rights lawyering. And then when I went out into the world and became a human rights lawyer and what I now know as a movement lawyer, I realized it's not just that they don't teach you in law school, but there really aren't that many organizations, present company accepted, that are practicing movement lawyering. And I was making, speeches and being asked to teach at legal clinics. And there was no book, there was no curriculum, there was nothing out there that actually took the wisdom and experience of the folks doing the work to write it down, put it in a book, package it up, and share that lived experience. And you know why? Because the people who are so busy doing the work on the ground, in the movements, on behalf of the movements, don't have time to write their story, to get it published, to get it into academia. And so we continue this cycle of learning from one or two kinds of experts that have a certain kind of experience, which is important, but in order to really shift power and transform systems and structures of injustice, we need folks who are often having the lived experience of that injustice to be leading the way and to be the experts. And that kind of expertise just isn't valued or certainly published in a traditional legal education or a traditional legal textbook. So that's why I wanted to pull this book together. And initially, I was like, well, I'm gonna, do all of the case studies and I'm gonna interview people and I'm going to write it. And as you'll see as you read this book and as you hear from the folks on the panel today, one of the real foundational principles of what all of the people who contributed to this book is that storytelling is a form of justice, and folks actually owning and telling and sharing their own experience is a critically important part of the process of justice, as well as a really good product, whether it's a lawsuit, an affidavit, or a book. And so the fact that actually I worked with a real writer who's not a lawyer to put together these stories and write them in a narrative-driven way, as opposed to a lawyerly rendition, which is a very different kind of storytelling, made it just an incredible experience, and I think also a really good read. This is not your typical legal textbook, and I think that makes it really good.
Thank you, Kate. So I want to turn to you, Alejandro. Let's get into the stories in the book. And you've been created Protest 2010, 2005. And one of the extraordinary things about working with Protest and the extraordinary about your work is that in the Mexican context in which you're based but expand, there are such things as social and economic rights, which BTW do not have in this country. Look in the Constitution, it doesn't exist. Tell us a little bit about the extraordinary work that you've been doing, how you came to the work, and the extraordinary work that you've been doing with Union Hidalgo, and the fight against companies that were looking to essentially take over their land and destroy their way of life.
Turn it off.
There's a delay.
Yeah, it's a, well, good night, everybody. Thank you, Vince, for the invitation and for the opportunity to share with all my friends here. We are colleagues, but also most of everything we are friends. We have been working together for several years and listening the strategies, but also the frustrations that this kind of work brings, and that is having this small community that is going to support you whatever happened with your case or your life or your partner or your sons or daughters is very valuable. So this is also important to things. No? And as Vince was also introducing the chapter that I wrote in the book, I'm a human rights lawyer, a Mexican lawyer with more than 20 years working on the defense of human rights in Mexico, but also in the Inter-American system and using the UN system and the international systems for using the international law for supporting the national litigation that I've been doing for all these years. And in 2005, I did found a project of economic, social, and human rights, PRODESC, which is a human rights organization based in Mexico City, but focused principally in the defense to the land, territory, and natural resources of indigenous communities and agrarian communities that are being affected not only for the action or the mission of the government, but also for the presence of transnational corporations. The other side of our work is defending labor rights, principally of female rights that are working on precarious conditions in different industries and supporting them for unionizing and also collective bargaining. We are a feminist organization, and we are also always pushing for developing our organizing or legal strategies from the intersectionality perspective, because we acknowledge that in the context that we are working, there are also different contexts to take in account for be respectful and also for trying for all means to avoid distraction from the communities and the social movements. So in all this work, one of the main cases, which is the case that I wrote about it, is the case of the community of Union Hidalgo. It's an indigenous community based in the state of Oaxaca in the south of Mexico. It's a Zapotec community. And among other communities based in the Istmo of Tehuantepec, they were suffering for extraction of one of the most important natural resources in that location, which is the wind. In all this conversation about just transition, several corporations came to Mexico to build wind parks on the land and the territory of indigenous communities. What happened is what is happening in other communities around the world. The corporations came, the government issued the concessions for generating energy, and without any consultation from the communities, they started to build more than 30 wind parks on their land and their territory. We started the case defending the land and the territory for the construction that already happened of two parks owned by a Spaniard corporation. But the wind parks were already built, and we tried to do principally reparations. No? The main damage was already there. And working in our strategic defense and the integral defense methodology that we have, we were also not only doing the legal analysis and litigation, but we were at the same time supporting the internal structure of the communities in order to have more strength for fighting and resisting, and also for achieving the general decision making about what is going to happen with the land. We, working with the community, we listen the rumor that another corporation was about to build a new park. Listening the rumor, we were issuing claims for under the law of transparency, identifying that the Mexican government were issuing at the time a new concession for Electricité de France. Electricité de France is a paraestatal corporation from energy from France, and they were planning to build not only another wind park in the land and the territory of Union Hidalgo, they were planning to build the biggest wind park of Latin America, which means for Unión Hidalgo to be enclosed and to stop the possibility to keep growing as a community and also all the cultural and economic applications that that could mean in the future. We support them for more than 11 years. We litigate at the national level also. We use the mechanisms, for example, of the National Contact Point from the guiding for the guidance of OECD and business and human rights. And when we were doing this dialogue under the National Contact Point with the corporation, the lawyers of the corporation, we flew from Mexico in company of representatives of the authorities of the community. And when we were in France, in Paris, trying to negotiate with the corporation, the lawyers of the corporation just told us and to the authorities of the communities, we are not really going to negotiate. If you don't want the park, you have to sue us. So we already sued them in Mexico, but in that moment, the community, the leaders were very frustrated. And also, behind the frustration, we saw that they were very sad because they always believe that there is an opportunity to have a dialogue. And when they saw this impact from the lawyers, they decided well, then we are going to suit you in your country, And happens to be this law about the French law of due vigilance and due diligence, which obligates French corporations to do the due diligence in the supply chain, even in the operations that are happening outside of the country, outside of France. With that law, we decided to sue Électricité de France in the court of Paris. We are still litigating, but with all that information, the proof that we were building on the process, we were able to also, in the litigation in Mexico, to cancel the contract between Électricité de France and the Federal Commission of Electricity, making inviable the construction of the park. So the community win. We were able to stop the construction. We were able to prevent the main damage for the land, the territory, and the natural resources. And also, which is very important for the experiences that we are having, it is a story of a community that was listened, that recover in the exercise of defending their rights, also the certainty that they have rights, they can demand their rights, and they can win. In a history in Mexico, where indigenous communities had been historically excluded and marginalized, that is a flip of 180 grades for agency and for social change, not only for Unión Hidalgo, but also for other indigenous communities or indigenous nations around the world and the global south principally. And the other important thing is this process lasts around probably 12 years. Social change takes time, takes a lot of expertise, interdisciplinary approach, understanding power, not only the power of corporations or the power of other actors, but also the collective power of communities that organize can really change their history. And I think that is part of why, as protests and lawyers, we find in these kind of cases the opportunity to keep building more than victories, spaces of hope. So that is the case.
story, Andrea, you told us that you have a case pending in Harris, but you're able to cancel the contract. Can you just tell a little bit about how you canceled the contract? This is like the dopest thing that I've ever heard. You know, about the research that you did and that sort of thing. What you learned.
Yeah, well, in the cases that we are litigating, we are doing corporate accountability, you know, which is a lot of understanding the law, but mostly understanding corporations, how corporations are working, and also how the commercial contracts between corporations are working. Part of the corporate research that we were able to understand thanks to other very well-known organization, which is specialized in corporate research called Empower. With all that information, we were able to have the contract between Electricité de France and the Federal Commission of Electricity. The contract established a period of time between Electricité de France and the Federal Commission of Electricity and the investors in the project, which established 3 years. After 3 years, the wind park had to be already built and generating energy. If the 3 years passed, the Federal Commission of Electricity had the possibility to cancel the contract because they will be losing money. So what we understood is, of course, law is important, human rights treaties are important, but corporations really don't like human rights. They don't even matter human rights. The language that they talk is about money and a material damage. No? So what we understood is, if we are able to keep pushing for delaying the litigation that we were doing in Mexico for more than 3 years, then we had the space of power to leverage the clause in the contract demanding for the cancellation of the contract. So we filed a case, well, we filed like my lawyers and brothers were like just creating new theory of law. It's very interesting, no? It's about law. So we were filing amparos for violations to the right to a free and prior consultation and consent for indigenous communities, for amparos for violations to access to information, for access to participation, every single right on the Mexican Constitution. We were just filing a case and delaying the day until we had this power space for leverage the clause in the contract. And when we just have the opportunity, we file the case, we won the case, but at the same time, important to say that in Mexico, the judicial system is very complicated. We have still a lot of corruption, impunity. So the law, even when you are a very good lawyer and you are working with very good lawyers and you are doing a very rigoristic strategy, you have to also be very creative. So what we decided to do is we would file the case, we were litigating, but at the same time, we made the argument with the Secretary of Energy in Mexico, the Federal Secretary of Energy, giving him all the information that we had. Memo that give all the information, gives them all the information, and making the argument how the Mexican government were losing money if they kept with the contract. And it was true. I mean, we were not inventing the information. It was true. It was proof there. And that also was another leverage of power for pushing for the cancellation. But this, social change and this kind of impact and litigation takes time, but you can also use the time in a strategic way for really winning.
Yes, that was a wonderful the wonderful movement and lawyer strategy around understanding how corporations work, what they care about, to be able to leverage those things. And so thank you. Also, I'm with the Center for Constitutional Rights. We also use Empower as well as a research arm, and the research, understanding where the money goes, how the money flows, what the rules are. None of us know, but as lawyers, we have a lot of privilege. We talk about privilege of lawyers. One of the benefits of having that privilege is that you can learn and digest a lot of information, which you can then share with your movement allies, and then come to a joint strategy about what people want to do. So when we get a little later, we're going to talk about some of the things that you can do as movement lawyers that are really useful. I want to turn to Professor Hansberry. Can I call you Professor? Professor? Sure. That's my friend Justin.
Sure.
And I met Justin. I met Justin when he was sort of writing some crazy brief while reality TV was on in his living room, and during Ferguson, when the world was burning and Black people were turning up. And I loved your piece in the book, and I want, if you could just talk a little bit about how you went from being the milkman to the middleman to the statesman.
Okay. I like the sound of it. I'm not sure, if this will exactly capture that. But so it makes some sense out of what he's talking about. So when Mike Brown was killed on August 9th of 2014, 10-year anniversary coming up this next August, I was living in St. Louis, about 10 minutes from Ferguson, and by that time I was a law professor already, a critical race theorist, and I was there watching a revolution launch in front of my eyes. And when I went out to the streets to join the people, there were tanks, there was tear gas, all the things, and actually the first thing I remember from that experience was that as we were getting tear gassed, and I was also tear gassed, and I have asthma. So when I was tear gassed, it was a bad situation. But I remember that we had learned to use milk to help to fight against the effects of the tear gas from some tweets that were sent out from Palestinians during that time. Saw what was happening online. This was the beginning of the use of Twitter to capture protests and things of that nature. And that moment of solidarity is really what led me to say, well, here I am, by that time I was a fancy lawyer, I was a law professor, all these different things. But it was very clear that in that moment, what people needed was milk. They didn't need a brief, they didn't need a Supreme Court argument, they needed milk. And so I had a card and I drove around and I bought some milk, a few gallons of milk, and went around and passed that out to people so that they could fight the effects of the tear gas. And that was perhaps the moment where I became a movement lawyer. Prior to that time, I was a critical race theorist. I believed in social justice and all this stuff. But I think that captured the spirit of what I interpret movement lawyering to be about, is really doing whatever needs to be done in the moment. They say people don't care what you know, they know that you care. I think it's the saying, but at that moment, I became a person that could be trusted by folks who were putting their very lives on the line for us, for our human rights. And so after that moment, I was dubbed the milkman. So that's why he said the milkman. So from being the milkman, I became, what's the next thing he said?
The middleman. People were calling on
middleman. So as a lawyer, what ends up happening is you, especially a movement lawyer or a radical lawyer, you're sort of straddling two worlds. You have the organizer world, but you're still, whether you like it or not, you're part of the system. You have that law license, You can say that you passed the bar or you've gotten your JD. Sometimes you walk around in a suit and tie. You're part of that world as well. So when things are turned up, people in the official world, the legal world, the political world see you as an entry point if you have that 1 foot in the movement or 1 foot in the system. And so you become the quote unquote middleman, so to speak. People come to you and like, they're really getting pretty restless. Why don't you tell people to calm down? And so you have to, work with your own emotions, right? Just to sometimes realize that, again, what is needed in the moment. You may want to tell that official to go take a flying leap to a certain place, but at the same time, oftentimes you know that your best use of your skill set at that time is being the entry point, the communication point between the movement and the system. There were times where, I recall one time where people were out protesting in front of the Ferguson Police Department, and it was raining, and there was a group, I forget the name of the group, Ashley and some of the group of protesters from Ferguson who were about to get arrested, and it was going to be a pretty violent arrest, I could tell. And it was 3 young black women, it was myself, and some few legal observers, and the police were converging. And I knew that this was going to be a very difficult arrest because of the situation. So I decided to approach the officers, and they were, one of them put their hand on their gun actually during that time. But the thing was, one of the lead officers, I don't think it was the chief, it was one of the captains, he knew who I was because I had been doing these TV shows, and I had been in these meetings as a policy advocate. I had been participating in lawsuits, and so he said, "Oh, that's Attorney Hansford, Professor Hansford, he can come through." So I go through, I talk to them about the situation, explain to them that this would be the wrong time to do the arrest. So I made a little legal argument at the time, and they decided to forego the arrest at that moment. And there's a lot of discussions we had afterwards as to the usefulness of that. That didn't end police brutality. That didn't change the system. But there's a little moment where I knew that my 1 foot in, 1 foot out stance may have helped eliminate the situation where there could be violence against people I cared about in the moment. So those moments of being a middleman, so to speak, can be very useful in the really stressful situations that are going to be inevitable when the protests are happening. Now, of course, there's some cons to being a middleman as well. So you're also not going to be fully seen as all the way down, all the way trusted on both sides, right? So you're never going to be, appointed to highfalutin position in the system. When you have 1 foot in the movement, people say, well, that guy's pretty radical. He might say something, we don't want to have said, so let's find someone who doesn't have that resume. Then on the other side, you come to the movement meeting and, you may not have a tie on, but you got like a sports jacket on. And
They can tell. It's like telling a cop,
Right.
They can just tell.
Even if you have a t-shirt on, you still walk like a lawyer, So and it took a while to build that trust. For me, I was a milkman, so people knew me. But if you don't have that type of situation, you're gonna have a hard time building trust. Because it's also true that many people in the movement have had very bad experiences with lawyers. Lawyers have betrayed movements for generations. For every Hayward Burns, there's a collection of attorneys who have been in a situation where they filtered the movement's goals through a legal lens to the extent that they end up centering the law as opposed to centering the movement. And to me, that's what movement lawyering another contribution of movement lawyering is centering the movement as opposed to centering rights talk or looking for the system to save us. You're looking for the movement to save us. You're looking for people to save us. So that tradition of the attorney in movement spaces is one that is that you're fighting against, to be blunt. We have our own tradition as radical lawyers and movement lawyers that some organizers know about, but I think that's the tradition we're trying to build forward and expand with our work. And this book does a great job of continuing that tradition for a global audience and a new generation.
The state, I should say, the middle person and the state person, but the state person, tell us a little bit about the taking that work to the United Nations.
Right, so the movement, if you remember those days, we were in the streets, we were in City Hall, but nothing was happening. And in November of 2014, I was actually teaching human rights law, and I had a friend, Nina Jagannath, who is another member of the board of the Center for Constitutional Rights, who approached me with an idea which involved taking the Ferguson protesters to the United Nations and arguing that what happened to Mike Brown and what happened to the protesters was not just a civil rights violation, but a human rights violation. And I immediately thought back to some of my heroes like Malcolm X, who always said that our struggle as a people is not just a civil rights issue, but it's a human rights issue, and we needed to go before the World Court of Justice to argue that. And I saw this as a chance to continue that legacy. One problem is that I didn't know Mike Brown's mother, and so I had to track her down. I went to her church, sort of sat in the back pew, and eventually got a chance to talk to the pastor who introduced me to her. We were able to put together a shadow report. So what these shadow reports are documents that allow human rights advocates to have an audience before different treaty bodies during their review process. At this particular time, we were undergoing the UN Convention Against Torture's review process in 2014. This Convention Against Torture, believe it or not, was signed under President Reagan. But we understood that what was happening in terms of police violence was a type of arbitrary use of state power, state violence against citizens, which fit within the definition of torture. What happened to Mike Brown, what's happened to his parents, what happened to protesters who were tear gassed unlawfully, who lost their First Amendment rights to protest. So we interviewed protesters, we went to the jails, we got their stories, we interviewed Mike Brown's family, and we did a GoFundMe, and we got enough money to go to Geneva, Switzerland. And I do have to say that in my legal career, the proudest moment of my legal career was working with Mike Brown's mother, going through that testimony with her. She cried, I cried. She talked about how she saw her son's dead body on the ground for 4 hours in the sun in St. Louis in August, and her feelings and her understanding of the situation was communicated to people from all across the world at the UN. They had their little earpieces in, and they were translating her words into all these different languages, and I could see the impact it had on her, because it was the only time in the entire experience that she had the chance to have her voice to be heard. We didn't have a criminal case because the prosecutors took that from us. We didn't get a civil case. So this was her platform, and she got a chance to argue that what happened to her son was something that was an international human rights violation. It was that significant. It was that important. It was that important to her, and it should be that important whenever it happens to any youth around the world. So after that, we got a favorable outcome from the UN in their concluding remarks. We were able to send that to the Ferguson authorities, St. Louis authorities, the governor at the time, Jay Nixon, and particularly with the arguments of the protesters. So not only Mike Brown's mother, but the protesters also spoke. They were talking about how the use of tear gas indiscriminately was harming their First Amendment rights, and the police were putting property over people, as they did during the George Floyd protests here 6 years later. So, we made it known that we would once again go to the UN when the decision as to whether or not to bring charges was made. We knew that there were going to be more protests when they decided not to bring charges. And so we knew that they needed to understand that we were watching, and we were going to make sure the UN was watching. So when that decision took place, and Bob McCullough, who was the Ferguson prosecutor, went on television and gave this long speech about how he was not going to bring any charges against Darren Wilson. So you all may remember that. The city went up in flames, but nobody was killed. And there was a directive that we found out, which was sent down, which was not to avoid violence at all costs, probably for political reasons and for optics, right? So that the problem when you have the UN mechanism, and I'll stop after this, but the UN mechanism's problem is that when you're dealing with these local officials, you have to think about what is your true leverage. You can't, it's not a financial incentive. You can't put them in jail per se. The ICC was not going to come and arrest Ferguson prosecutors, the International Criminal Court. But there's this idea that naming and shaming is the greatest tool of the human rights apparatus in many cases, and that doesn't work if you have a president like some of the presidents we've had who don't shame very easily. But in this particular situation, we had a Democratic governor. Believe it or not, Bob McCullough was a democratically elected prosecutor who later was ejected thanks to the work of the Black Lives Matter movement. But you had a number of Democratic politicians who, in that particular environment, were afraid of the backlash, I believe, of the human rights advocates and the publicity that could possibly hurt their political futures. So we had a small bit of leverage using that international human rights mechanism that was completely denied to us through local legal mechanisms. So we felt that there was some movement, and it was a rewarding experience. Of course, coming up on the 10-year anniversary in August, there's going to be a lot of reflection as to what has really changed, both in Ferguson and nationally, but my time is up. So I do want to say that it was a wonderful experience, and I enjoyed talking about it in the chat.
Thank you. And there are a couple of pieces I want to pull out. One is from the stories so far that we've actually heard about the importance of finding that space of leverage. In both of the stories we've heard about one of the really important goals in lawyering is to be able to create space for movement to be able to happen, whether it's a 3-year space to in one context, or whether it's actually doing harm reduction in the moment on the front line. And we also heard about the importance of international solidarity, and I think most importantly, the idea that, and this is part of the movement lawyering ethos, is that our fates are combined, that the folks in Ferguson were believing that they could not be free unless the folks in Palestine were free, and the folks in Palestine were saying that they could not be free unless the folks in Ferguson were free. And I want to sort of stay in Geneva for a second and kick it to, can I call you Professor Askin? Dr. Askin, legal director of the Center for Constitutional Rights. There was a really interesting exchange when and the other piece is every lawyer on the planet, except for the lawyers in this room and in this space, will tell you the last thing you should do is let your client talk. And every story that we've heard right now has been about supporting and lifting up the voices and letting people tell their own stories, which are more powerful. So there was a really interesting exchange in Geneva because Justin was with the Brown family, and Bahar Azmi was there in his context of working with Guantanamo detainees. And if you could just tell the story of what happened when your people and Justin's people met.
Sure.
And then we'll talk about stop and frisk.
Yeah, that was fast. I was there with Murat Kornaz, who was I represented while he was detained in Guantanamo. Was released in 2006, and it was a hearing of the Convention on Torture, and there were a number of groups there. The Brown family, amazing youth-led organization in Chicago called We Charge Genocide. Another partner from SNAP, Survivors Network of Those Abused by Priests, were there. Survivors of military rape, and my client, Ron Karnaz, was there to confront the United States directly for the first time about torture in Guantanamo. And two observations about that. One, so my client is not at all political. I mean, he sort of obviously became political, but as he was watching all the testimony, one thing that occurred, he turned to me and he said, that, remember, I mean, it's just not political at all, doesn't watch the news. He said, oh, in America, the police kill black people. Like as if, you know, America is a federation of 50 states bounded by the Atlantic on one side, the Pacific on the other side, and also, this is what happens. And he just didn't know it, but that was like, he pulled out the essence of America in that moment. And then he spoke and learned a lot, and it was really interesting because there were, you know, a lot of the We Charge Genocide folks, and even the Brown family, dude, you were in Guantanamo. That's heavy. And there was like a really beautiful moment of solidarity. I have a gorgeous picture with the Brown parents and Murat together. Yeah, beautiful moment of solidarity.
Tell us about hope, and as Alejandro was talking about, the importance of evidence and the stop and frisk work that CCR did.
Yeah.
And the importance of being able to name the things that were happening in the context of the stop and frisk trial and the movement history of the stop and frisk.
Yeah, so my piece is it's called Who Owns the Streets, and it starts from this revelatory testimony played in the open court, reported by a whistleblower in a command meeting where the lieutenant was instructing everyone to clear the block and saying, you know, not unlike in Ferguson. What did they say in Ferguson? We own the night? No, that was the street crime unit. What did they say?
Whose streets are streets?
Whose streets are streets? Yeah. So right, the NYPD street crimes unit, we own the night. Whose streets are streets? But the cops and the modern NYPD is we own the streets. They don't own the streets. We own the block. Move them. And that sort of authoritarian moment is a premise for thinking about the strategy to try and at least nominally take back the streets and shift power from NYPD to communities. And, you know, like everyone here, we think critically about the law and limitations of impact litigation and, you know, where its deficits are. And, you know, like everyone here, we've been thinking about particularly now the limitations of litigating for rights recognition as such, for the simple recognition of rights, because these things are not durable, absent some infrastructure, some power, some community force behind them. I believe in rights as recognition, like seeking rights for the purposes of power building and for the dignity of clients and communities. And so instead, thinking about ways to thinking less about rights and more about power, challenging power through destabilizing narratives from state actors or corporate actors, and building power, using litigation to leverage the work of communities. And so this is a little bit about I think its main benefit is just sort of concreteness, because when we talk about movement lawyering, it's a little bit abstract, and how do you marry movement lawyering with impact litigation, which is so lawyer-driven? But I think there were a number of things that the lawyers and the organizers did around stop and frisk that were kind of self-consciously in response to a kind of previously failed effort in 2003 to challenge stop and frisk. And the lesson was it largely failed because in 2003, the once vibrant police accountability movement, the post-Giuliani era, had melted away because of 9/11, and the settlement was correspondingly pretty weak. So in refiling the Floyd stop and frisk case in 2008, we're really mindful in ensuring that the community be part of the litigation. And so there are ways in which the litigation fed the movement, and the movement fed the litigation in kind of powerful and symbiotic ways. I mean, one way the litigation fed the movement is, the choice of plaintiffs. It's not, it's been suggested we all believe in centering impacted people, not necessarily the kind of mantra of the perfect plaintiff, the one that, a judge or sort of white middle-class American thinks is deserving of rights recognition. So our plaintiffs were David, now DeSaul Floyd, who was the head of for a while, the Malcolm X grassroots movement, was part of Cop Watch. Lilith Clarkson was also from MXGM. David Auerlich, CUNY graduate, was not political when he was stopped 3 times. But after this experience, went to CUNY Law School, became a public defender at Legal Aid. And so that really came by having community leaders as part of the litigation that came out in the testimony, their preferences and their legitimacy in talking for the community. And their testimony was, we want community input in our future and control of police. A second way the litigation fed the movement was one thing that came out of the prior settlement was a little bit of a poison pill for the city. They agreed to turn over all of the forms. They're called UF-250s. That includes demographic information, place of a stop, race, gender, and the reasons for the stop. So they turned over 4.4 million pieces of data because stop and frisk went from, at the time of this, it shows you, at the time of the settlement, there were maybe 240,000 stops a year. By 2011, the peak, there were 680,000 a year, 22,000 a day. And the way communities were talking about it, and this was also, we were trying to document through lobbying in city council and report writing, is that racialized occupation, people talked about Palestine, feeling that way. So we took the data, we had it analyzed, and it showed massive racial disparities, 83% Black and Latino individuals stopped, that was the prominent reason. It showed these numbers, and rather than holding all of this evidence like in a drawer and waiting for summary judgment to sort of unleash it as exhibits in the court, we were very actively sharing it with community members. And that was, I think, really effective because it's, it's one thing, and I don't mean this word disparagingly, for people to talk anecdotally about, man, this is really happening all the time. What is it to have like this powerful data? It really helped the organizing. So we're not, look at what's going on. And that fed the organizing. A third way the litigation fed the movement was in co-creating a remedy in the case. Just before the case went to trial, the judge asked, if plaintiffs win, what remedy should I enter? And we had some ideas as lawyers, but also done a fair amount of research on like how do we get community involvement in a remedial process, and had a 2-day-long convening with all of the lead police accountability organizers led by Communities United for Police Reform and the lawyers, and brought in people from Cincinnati who had previously developed a community collaborative process to change the police, and decided at the end of this, remember at the end of this meeting, you're gonna have this easel and put all of the things that we were gonna agree upon. Everyone voted, including the organizers, to ask for these remedies, including asking for a community process. That's what we asked the court for. We called it a joint remedial process, so that while the experts were thinking a little bit about what training and what racial profiling policy should look like, what would impacted community members also want to see outside of the lawyer-driven process. And let me talk quickly about how the movement fed the litigation at the same time. I think one of the most prominent way was an intentional, well, there were strategic communications that were working at the same time. There is something about, as Juven Kent talks about, there's something about a litigation that provides leverage, particularly like a very big litigation. So they had way more truck with city council members, given that there was a case about to go to trial and evidence coming out that supported their narratives. Just a really key thing was, the one limitation, the co-creation part responds to like a key critique of impact litigation, which is accountability. Lawyers are not going to be the ones who live with the particular remedy, so how do we not replicate this huge privilege distance between lawyers and those who are going to have bear the impact of the remedy. The second critique of impact litigation is it's very, very narrow. I mean, stop and frisk was a huge thing, but it really only dealt with street encounters. Didn't deal with police killings, although that was behind the initial strategies. Reduce the number of street encounters, you might reduce the number of killings. It didn't deal with Muslim surveillance. It didn't deal with a host of policing wrongs, let alone the sort of fundamental social problems driving policing segregation and poor healthcare outcomes, all of those things. So the CPR, Communities United for Police Reform, developed this very intentional pack the court strategy. So almost every day there were constituencies in the courtrooms of different people, different communities impacted by stop and frisk. So not just street encounters. There, one days there were public housing residents. Another day there were families of those killed by police. Another day there were Muslim constituencies upset about surveillance that wasn't on trial, but they would then have a press conference at the lunch break and bring their stories out. And I'm going to tell one really, really powerful anecdote about how this worked, how communities coming to the courtroom really worked. There's the chief Esposito, the highest ranking uniformed officer, really boastful, brash, dismissive person, said on the stand, this is what the community wants. They want more policing. And on cross-examination, someone said, "You've spoken to the community?" He said, "Yeah, I've spoken to the community all the time." And this was, I thought it was intentional. He said this just as a cosmic coincidence. The courtroom was packed with public housing residents, the ones he said he was talking to. Like you, audible guffawing, laughter, mockery. And Judge Shindlin looks in and asks him again, "Are you saying you talked with the community and this is what they want?" He had some snide thing, including the ACLU and Al Sharpton, but they're not really the community. Anyway, so he repeated the statement. And later, in her opinion, she writes, on the question of what the community wants, "I find Chief Esposito not credible." In other words, the community testified and she agreed with them and not him. And that was a persistent credit to CPR in interjecting themselves into the courtroom. They were amicus briefs for the court. They were present and the court saw them. And one outcome of that is after we won this really landmark judgment 10 years ago, there was a separate opinion talking about what remedies should happen, an independent monitor, a lot of the things coming from the evidence in the case. But she also agreed to this joint remedial process and the sort of elaborate process where you could, again, get input from community members about what reforms they want separate from what the lawyers could conceive. And in doing so, she had this really, I think, powerful line. I'm going to paraphrase it because I've forgotten it. But essentially, no one is more expert on policing matters than those who are most impacted by policing. So they will be part of the process.
Powerful. Katie, you've done so much work in international human rights around climate and the environment. And tell us a little bit about what was going on in Burma and the case against Unocal and also what I mean about what's going on in Burma, like the political context. This political context is everything in this work. It's one of the things that radical and social justice and movement lawyers take into account. It's the context. What was the context that was going on? How did you come to, and the community come to think about lawsuits, and what did the activists and organizers provide, and what are the pieces that the litigation could connect with?
Thanks. Oh my God, I just could like talk to you guys forever. This is so cool. You're so lucky. Oh my gosh. Yeah, so I mean, when I went to law school, not having any of this kind of inspiration, I had actually in between college and law school lived, it wasn't the Peace Corps, but it was similar to the Peace Corps in Thailand on the Thai-Burma border, done a lot of work in a refugee camp. And at that time, in the early 90s, Burma was actually, like now, it's kind of come full circle under the rule of one of the most brutal military juntas in the world, and a pariah regime, really with one of like the worst human rights records. And I was living in a refugee camp where people were literally running for their lives across the border, and I could, hear the bombing and the shelling, and saw with, great regularity, egregious human rights abuses and the impacts of those. And so when I went back to law school, the folks that I was living with said, you're going back to America, which is like the best democracy in the world, with the best human rights in the world. And I actually was like, yeah, please, as a lawyer, use your freedom and your privilege to help us get our freedom and our rights. And those words were really ringing in my ears as I walked into law school and thinking like, yes, I'm gonna be that champion and be that person who uses the law as a tool for justice and human rights, and helping the movement for democracy and an end to military rule in Burma. And very quickly realized that law school was very much not about actually transforming and shifting power and systems and structures, but a tool that is very much used to preserve systems and structures of power. And even, in the strategic litigation courses or impact litigation courses, professors would say, like, don't try to do too much at once, because that will be scary to judges, and you're always relying on past precedent. Like, Your Honor, this is really not that much different from such and such case. And so when I was thinking about, like, actually you need transformative, radical power shift, people power, not military power, or people power, not corporate power, I very quickly became disillusioned that, like, oh, the law as traditionally taught and interpreted is not necessarily going to do it by itself. And at this time in the early 90s, as I said, Burma was a pariah regime, and the United States actually had sanctions. And the world, it was known as like the movement for a free Burma, modeled its movement. They called it the South Africa of the 90s. And they modeled the global movement, and the students and the activists in the Free Burma movement in Burma really was inspired by the anti-apartheid movement. And so sanctions was one of the demands, and they did get global sanctions for the most part. But by the time the United States had passed sanctions, there were two companies that had already gone in to invest in Burma, and they were grandfathered, so they didn't have to pull out, but they were allowed to stay. And guess what? They were oil companies. And one of them, Unocal, which is now Chevron, was acquired by Chevron, had actually gone into a contractual arrangement with the Burmese military, had hired the Burmese military to provide security for a natural gas pipeline where it was extracting and producing and developing gas in the Andaman Sea off the west coast of Burma and India. But because Burma didn't have and still doesn't have the capacity to develop and then produce and refine and export it, they had to build a pipeline through Burma into Thailand, where they had the refineries and the infrastructure and the capability to get that gas to market. At the same time, also, Thailand wasn't under sanctions, so the World Bank, the Asian Development Bank, all the international financial institutions could fund all that infrastructure to get that gas to market. In hiring the Burmese military, which was notorious for slave labor, torture, crimes against humanity, rape, extrajudicial killings, in the context of what they called security, this is what this American oil company hired this military to do. And it's like, okay, speaking like a lawyer, it's pretty reasonably foreseeable that if you hire torturers and rapists and killers to provide security, what are they gonna do? They're gonna do what they always do. And so this is happening while I'm going to law school, and I'm going back and forth doing my summer internships at the human rights organization. And I have this incredibly, this moment that I'll never forget in 1994, speaking with a student, someone my age actually, because the students, the Barefoot Student Army, were, as they often are, the sort of leaders of the movement to overthrow the dictatorship. And when that didn't work non-violently, they fled to the jungle and they took up arms. And the student was like, okay, well, you're American Oil Company. I'm like, well, it's not mine. But they are ambassadors, so, and your American Oil Company is, causing all these human rights abuses. Our people are dying. We have written letters to the company. We have written letters to the banks. We have written letters to President Clinton, who, by the way, at that point said, global markets and corporate globalization and economic development will open markets lead to open societies. Wasn't working out so well in Burma, and they were like, and we've written letters to everyone, and yet the human rights abuses continue. UNICAL keeps doing this. So would it be illegal for us to blow up the pipeline? And I was like, well, I'm only a second year, so I haven't learned that yet.
There's an ethics class going on somewhere right now.
Oh my God, yeah, I know. I might not have always showed up to my ethics class, but I don't think they were teaching that. But I mean, that was it's like two tools in the toolbox, writing letters and blowing stuff up. And so I'm like, but I know, because I've taken human rights, that this is illegal. Pretty sure that torture, forced labor, rape, illegal. So I go back to law school for my third year. I'm like, I'm gonna write a paper. I talked to the experts and my professors, Jack Goldsmith. This is what's happening, and we can sue this company, right? Because this is illegal and this would never happen in the United States. And all of the experts who were right at the time said, no, you can't sue, because corporations are above the law when it comes to human rights abuses. Jurisdiction, this is a tort. And we all know, where does jurisdiction arrive? Where the tort happened. And so you have to sue them in Burma. Well, that's great. There's no functioning judiciary, and you're just gonna put a target on your back, and that's, so I remembered, one of the first things that I learned in Civ Pro is the law is dynamic and it is there to be changed. Sometimes you just need the right facts. And these were the right facts, we thought, to change the law of corporate accountability under human rights law. And I think that's one of the lessons of the book. And in addition to the chapter that I write about the UNICAL case, I also write at the end rules for radical lawyers, all the things they didn't teach me in law school that I had to learn and that we all came up with together in writing this book. But the best facts and the best clients are often the people who have had the most horrific, horrible things happen to them. And we have to remember that as lawyers, that our best clients are people who have suffered incredibly and are traumatized, and that is something that the law can never truly address, right? But we had, expert after expert after expert when we said we're going to use the UNICAL, UNICAL in Burma and complicity and crimes against humanity as the case that will change the law, and all of them said, and I wrote a paper on it, and my professor gave me an A-. And he said, Katie, you've made the best possible argument with a losing argument. This will never happen. It's impossible. It's unconstitutional. It's a terrible idea. This is not what the law is meant to address. And, basically wake up and smell the coffee. And I had like a moment of like, oh. And then I was like, well, you're just saying that it's impossible and it can't happen because nobody's ever done it before. And we graduated from law school. We started Earth Rights International literally for the sole purpose of suing oil companies and suing UNICAL for human rights abuses in Burma. Luckily, we were smart enough to know as first-year lawyers out of law school that we needed some people who had a little bit of experience, so we co-counseled with the great people at Center for Constitutional Rights who did know what they were doing, and who actually said, oh my gosh, these are exactly the facts that we need to change this law, which the law is just no longer suited for the reality of the world today. In a world of corporate globalization, international human rights law needs to catch up. Within the first 2 years of graduating from law school, we filed the case and won. Jurisdiction became the first case in the United States where a corporation was allowed to be sued for human rights abuses overseas. So I emailed my professor. I think the text of the email was something like that, and then went on. 10 years later. I mean, it took a long time, and there were a lot of ups and downs. But on the eve of trial, basically, where these companies, and then we brought other cases in the wake of that precedent, and the company settled on the eve of trial, and first time outside of the Holocaust context that a corporation paid for human rights abuses. And to Alejandra's point, they don't care about whether they're violating human rights, but boy, do they care about having to pay and having a lawsuit hanging over their head at shareholder meetings. A lawsuit for crimes against humanity, rape, torture, and killing doesn't go over well with the shareholders, certainly doesn't go over well with the media. And so all the way before we won, in the legal sense, the settlement, we had won in the court of public opinion. And pretty much every other company after that, nobody went into Burma. I mean, there was a time when some journalist from the South Morning China News or whatever called me and said, could you bring these kinds of cases against Chinese corporations? And I was like, oh yeah, definitely. And I'm thinking, I have no idea how, but I'm gonna say yes because I want the China. And truly nobody went into Burma the entire time. And so I always say, it actually doesn't matter if you win the case, it matters if you win the movement and you win the power. Because what that did was it shifted power immediately away from absolute total power of these companies who thought that they were above the law because they were, to an entirely different legal landscape. And by the way, the generals of Burma didn't care what their people said, they didn't care what the international media said, they didn't care what the United Nations said, but boy, they cared about what UNICAL said to them. And UNICAL went to them and said, this is causing us problems with our shareholders, with the media, with the US government, with our bottom line, and you have to stop killing people. And forcing them to work on this pipeline because this makes us look bad. Now, we would love a world in which they would have said that before all these things happened, but that's what shifts. So I think that that at the end of the day, and nobody told me in law school that when you're coming up with your legal strategy, are you asking the question, is this a winning legal strategy? Because you could win a case that has absolutely no impact for the actual communities or for shifting power or for transforming the systems and structures that allowed for those harms to happen. The question you need to ask is, are you going to win power shift and systemic change all along the way? And that's a lot less about the specific legal strategy and a lot more about how you actually litigate that case and how you build an ecosystem and an infrastructure and a world of advocacy strategies around it that you use the legal strategy not just as an end in itself, but a means to an end. Process is as important, if not more important, than product, and certainly as lawyers, we can understand the importance of process. And so I think that we have, 26 stories and I call them stories because they do read. People are like, like my friends who obligatory bought the book and then they're like, oh, it's actually really, it's great. I feel like I'm reading a book of short stories, and I'm like, well, you are. And storytelling, as we've heard, is a form of justice. Bearing witness is actually a form of being and feeling powerful and being heard and seen. And that is part of the legal process, regardless of what the jury or the judge does at the end of the day.
Thank you. I have some questions that I want to ask, but I actually want to open up and for your questions, comments, and insights. So please, how are we doing the mics? Am I handing this to somebody?
I'll use these and I'll distribute them.
Okay.
So, you just share it out.
Sure, this one, that's perfect. As people are sort of thinking about what they want to ask, I just wanted to see if there was anything from anybody that had some insights or connections, things that resonated that from different contexts that other folks kind of were talking about.
I just want to say one thing that Alejandra didn't say, but I will never forget you saying this at Bellagio when we were having the initial conference was, you said the role of the lawyer is to buy the community's time. Time to organize themselves, time to learn, time to strategize, time to build power. And I think I don't want to lose that because, especially in the context of everything, but we talk about justice delayed is justice denied. Well, injustice delayed is injustice denied also. And if we can use whatever access or strategy or whatever we have to buy the community's time, that's also in that statement is a recognition of who actually has the power and who has to be the architects of their own solutions. The folks who are closest to the harms are also the closest to the solutions. And so the notion of time, I think, is really important. We didn't touch on it, and so you said it though, my friend.